The Department of Justice is still tight-lipped about the reason for the search warrant. So what did it take to issue such an unprecedented search, and what could they be looking for? Joining me now, some of the most experienced former prosecutors and investigators, former senior FBI official and former U.S. Attorney Chuck Rosenberg, former U.S. Attorney Joyce Vance, former FBI Assistant Director for Counterintelligence Frank Figliuzzi. Chuck Rosenberg, first to you. The former president is apparently claiming he has the sole right to declassify documents, and that he declassified them before he removed them from the White House. Theoretically, if he did declassify them before noon on January 20th, when he stopped becoming president, of course, does that exonerate him from any potential violation of mishandling classified documents?
Well, Andrea, it's a great question, a bit of a theoretical one. A sitting president has the right, the privilege, the authority to classify and declassify. The entire intelligence structure is built for the ultimate consumer, the president. Whether or not he actually did declassify it is a factual question. We don't know the answer to it yet. And by the way, this may sound like sort of a conjecture rabbit hole, but I guess it's also possible that President Biden could reclassify documents. You know, President George W. Bush did that shortly after 9/11, reclassified certain documents for other reasons, not nefarious. So presidents, sitting presidents, have that authority, and that authority now resides with Mr. Biden. But we don't know what the basis for the search warrant was specifically, what statute he allegedly violated. Remember, at this stage, the FBI and prosecutors only need to show probable cause. It's an investigative step. It's not the final step or the burden of proof necessary for conviction. So we need to see the affidavit, and we need to understand more precisely the basis for the warrant.
Joyce Vance, Donald Trump said that his safe was searched. So how significant is that? Or is that just part of what you would assume, since they'd established probable cause, that they were looking for something, and that something, some evidence that could be criminal was somewhere on the property? They could search anywhere they wanted.
Well, it's interesting as a tidbit. It gives us some clues. First, of course, we need to acknowledge that this is filtered through the former president's interpretation of events, and there's no way of knowing whether this is accurate. It's entirely possible that the FBI had access to the safe, that they were able to get into it without, as the former president said, breaking it open. Maybe they did have to do that to get inside. What it tells us is that they had probable cause to search for evidence of crimes that they believed would be found inside of the safe, or something like a safe. So when prosecutors think about this, when you're executing a search warrant, you can advise agents to look any place where the items you have probable cause to search for could be. That means that if you're, for instance, looking for, let's just be silly and say, a stolen elephant, you can't look for a stolen elephant inside of a safe because it wouldn't fit there. But you can look for documents. So it's a little bit of a tip-off as to what they were entitled to search for.
And Frank, take us behind the scenes. Just how does the FBI execute these search warrants? In this case, they were notifying the Secret Service, so it was one branch of government to another branch of government. Secret Service guards every property of a former president. So they would be at Trump Tower, they would be in Bedminster, they would be at Mar-a-Lago, and they were clearly there.
Yeah, so after, of course, everyone has signed off in Washington, and then at the U.S. Attorney's Office or DOJ, and then after, of course, the agents have spent time with a U.S. federal judge or magistrate, and that judge or magistrate has been convinced and asked all their questions about whether this is truly necessary, and every other possible resolution has been exhausted. Then you've got to get your evidence team together. And largely, this was likely out of FBI Miami, the fifth largest FBI office in the United States, an outstanding, experienced evidence team. You're going to want your best folks on this, particularly those with documents experience, maybe even electronic device experience, whatever's certified and authorized to search in the warrant. And then you're going to want to be secure in your search, and they take things very seriously regarding safety and security. You may recall that not long ago, FBI Miami actually lost 2 agents. They were killed executing a warrant involving child pornography. Not something in terms of fatality that happens every day. So it's a violent environment down there. They would make sure that Secret Service understands they're coming in armed. They're coming in with a lawful court-authorized search warrant. They're going to ask questions likely about security there, private Mar-a-Lago security, cameras that might exist to secure the resort side of things, cameras that might exist even belonging to the Secret Service that might have recorded the actions of the agents. And there might have been a discussion about whether or not those cameras would remain on or off. All of that has to go into it. There's a methodical cataloging of all the documents and things that they took, usually photographing things before and after to help against allegations that they broke something or to prove they needed to break something. And then the receipts, the return, it's called, handed back to Trump's attorneys, showing them what they took.
And Chuck, how specific, even to get the warrant, do they have to categorize what the evidence is and to establish the probable cause?
Yeah, so probable cause is the lowest threshold in the criminal law. It means more or less, Andrea, probably. But nevertheless, with a warrant like this for a search target like Mr. Trump, I'm convinced that this would be an exhaustive recitation of facts, everything the government has. And not only would it be exhaustive, it would have been fly-specked, unlike perhaps any other affidavit in recent memory at the Department of Justice. In other words, you don't want to go to a judge in a case like this with merely probable cause, unless, of course, that's all they have. You want to go to the judge and show that there's a compelling reason to search. Now, the Fourth Amendment doesn't require compelling evidence. It requires probable cause. But as a federal prosecutor, and Joyce knows this and Frank knows this, we often put in much more detail than the Fourth Amendment would require. And as Frank alluded, to satisfy any question or any concern that the federal judge may have. So you're asking for things with specificity and with a strong showing that that a crime was committed and that you're going to find evidence of the crime at the place you're asking to search.
And Joyce, the Ways and Means Committee, on a different issue, but one that has been litigated all the way up and down from the Supreme Court. The Ways and Means Committee on the House side, obviously, has just tweeted out that the D.C. Court of Appeals has just ruled that the law is on its side in seeking Trump's tax returns. So we expect to receive the requested tax returns and audit files immediately. This goes all the way back. It went up to the Supreme Court. They referred it back to the appeals court for a final decision. So this does appear to be final, that he's going to have to turn over his tax returns to the House Ways and Means Committee, right?
Yeah, I'm not certain that it's quite that final yet. It's possible that Trump could ask the en banc court to reconsider this ruling and that there could be some additional appellate maneuvering that might stay the time a little bit. But this is a very compelling 30-plus page opinion from the Court of Appeals, and they definitively go through each of Trump's claims and reject them, holding that when the law says that materials shall be turned over to the committee, it means that they shall be turned over as long as there's a legitimate legislative purpose. And they say that the committee is well within its rights here because it has authority over presidential audit measures. So it looks like one way or the other, the committee will get what it's asked for soon.
And Chuck, last night with Rachel, you said you were just astonished by this all happening. You found it astonishing. And you also talked about how meticulous it has to be in this case to meet, the standard. And that Merrick Garland, contrary to all of the accusations and what Kevin McCarthy said, that Merrick Garland would be so careful about this, as would the FBI, especially because of the recent history where the FBI did stumble and had, a bad warrant. Take us through that.
Yeah, absolutely. So, look, we always try to be careful as prosecutors and agents. I've always tried to be careful with any search warrant, with any arrest warrant, with any indictment, with any presentation of evidence. And that's in our nature, and that's what we should do, and that's what we try to do. That said, Andrea, this is quite literally unprecedented. It's a former president of the United States. And a case like this is going to be under enormous scrutiny. The affidavit has to be tight and compelling. You have to have multiple people review it for accuracy. And so it is astonishing. It hasn't happened before, and that's astonishing.
And the issue of national security, how important is it for national security documents, that law that you can about handling or mishandling national security classified documents? Chuck?
Right. So there are several ways to think about it. You know, there are criminal penalties attached to retaining documents that you shouldn't retain if they're classified, mishandling them, in the worst case, transmitting them to a foreign power to try and injure the United States. There's a whole suite of crimes. We don't know which crime was specified in the affidavit. We'll learn that at some point. But classified information is extraordinarily serious in some cases and has to be handled with great care. And if that wasn't done, and it wasn't done on purpose, that can be a crime.
Chuck Rosenberg, Joyce Vance, Frank Figliuzzi, our best experts. Thank you all so very much.